There you go. Good morning. Welcome to the April argument session of the Pennsylvania Supreme Court. It's my first opportunity to sit as the Chief Justice. I want to thank all my colleagues who have been so gracious in allowing for this transition. And obviously, I especially want to thank my dear friend and esteemed colleague, Tom Saylor, who remains a valuable member of the court and irreplaceable to me as an advisor and a colleague and a friend, and chose, because it was his view that 1 year was not sufficient to be chief, to voluntarily step down as of April 1st and swear me in last week. I look forward to doing the best I can to lead the court in the same direction that Chief Justice Saylor led it. It's a fine court, and I'm proud to be a member of it and now to be the Chief Justice. Our first case today is Keystone Rx versus the Bureau of Workers' Compensation. And it falls to me in the role of Chief to introduce this by saying a few words as to what it's about. So counsel, listen, and if I misapprehend something, certainly explain it to me and all of us. In 2004, Thomas Shaw suffered a workplace injury, after which he was prescribed medications, which was dispensed by a pharmacy, which is the appellee herein. A utilization review was held in accord with the workers' compensation, in which the pharmacy was not permitted to participate, and it was determined that the claimant's relevant medical treatment, which includes the prescriptions at issue, was not reasonable nor necessary. The Commonwealth Court held that prospectively only non-treating providers, such as this pharmacy, shall be afforded notice and opportunity to establish the right to intervene in utilization proceedings employed to determine if medical treatment is necessary or reasonable. Stated broadly, the issue in the case is whether due process requires that a non-treating provider, such as the pharmacy, be permitted to participate in utilization reviews in accordance with the Workers' Compensation Act. Ms. Smith and Mr. McCoy, you jointly represent, one represents the Workers' Compensation Bureau and the other the insurer. Yeah, I understand you're going to divide your time. We've said in advance that we have what has been referred to in the past as the no piling on rule. Please don't repeat your argument. If we ask a question to the first of you to argue that is better addressed to the second, feel free to tell us. We'll remember the question. Whoever is going to argue second will remember the answer, and we can get to it that way. So you're not tripping over each other. But this issue, I will respectfully stop. Okay. Whoever's arguing first, please introduce yourself. If I've made some mistake, let us know and proceed. And you have 2 minutes in which we will try very hard to not interrupt you.
Good morning, Your Honor. My name is Kelly Smith, and I represent the Department of Labor and Industry and its Bureau of Workers' Compensation in this matter. I will address your questions regarding separation of powers, consistency of the department's regulations, and due process, and my colleague, Mr. McCoy, will address questions regarding the impact of the holding on insurance carriers and the armor cases. The Pennsylvania Workers' Compensation Act exists to compensate injured workers for wage loss and medical expenses caused by work-related injuries. It does not exist for the benefit or to create a risk-free business model for pharmacies and other non-treating entities that simply fill the order of a treating physician. Commonwealth Court lost sight of that with a one-sentence holding on the utilization review process, a process that was not even before it. The case before Commonwealth Court was a medical fee review proceeding. Nonetheless, in that one sentence, the court significantly altered the legislative scheme created by the General Assembly. The court's action in augmenting that scheme is a violation of the separation of powers doctrine that can only stand if it is necessary to remedy a due process violation. Here, there is no due process violation. The court was wrong. It's wrong, we know that, because the United States Supreme Court, in the Sullivan case, interpreting this precise section of the Pennsylvania Workers' Compensation Act held that there cannot be an entitlement to medical payment for medical benefits unless and until the treatment is determined to be reasonable and necessary. That is what the utilization review process addresses. By creating a right to intervene in those proceedings, Commonwealth Court has significantly upset a comprehensive legislative scheme determined to adjudicate those disputes and given a role to a party that has nothing to offer to that proceeding. These non-treating entities do not examine the claimant. They are not aware of the claimant's diagnosis, details of the accident, or the treatment plan for the claimant. They merely fulfill an order. They have nothing to offer with regard to reasonableness and necessity, something that is determined by a specialist of like license and specialty to the treating physician.
Ms. Smith, you're 2 minutes into your argument, so I'm going to welcome questions from our colleagues, so they could have always asked you. But I'll ask you the first. I'm not sure you're incorrect in terms of the case, but I don't see it as a separations of power case. I thought that was a wrong way to approach it. To the extent that this court, or any court, would determine that the statute or the implementation of the statute violates due process, it's the inherent role of the court, going back to Marbury versus Madison, to enforce the Constitution. And that certainly is not a deprivation, or it's not a infringement of separation of powers.
It's not if a due process violation exists. I agree with you, Your Honor. The problem here is that no due process violation exists.
So why don't you argue it that way?
I thought I just did argue it that way, yeah.
So, counsel, this is Justice Doherty. As we know from Sullivan, a due process would be a deprivation of a property interest. How is it not to be argued that the property interest for the pharmacy is actually its financial expenditure in purchasing those narcotics that are being dispensed per a valid prescription at the time of dispensing? How is that not considered or construed separate and apart? Their ability is a violation of due process for a UR not to include them.
Because a UR is not determined it's not to determine payment issues in general. It's to determine payment under the Workers' Compensation Act. And if the treatment is not reasonable or necessary, regardless of any expenditure, it can't be reimbursed by the workers' compensation insurance carrier.
And what is to take this to the logical extreme, if they're not permitted to recover from the insurers, where are they supposed to get the recovery from?
There are any number of factual scenarios, quite frankly, Your Honor, and I wouldn't want to sit here and speculate or run through them all. Certainly, there could be other liable insurance carriers. Many times work-related injuries are caused by a product's liability or a third-party tort case. There are any number of other places they could go. In addition to that, this is a system that they have entered into knowing the risks, knowing the boundaries, and it's a business model that they've chosen.
Counsel, this is Justice Donahue, just following up on Justice Doherty's question. Why isn't the patient ultimately responsible for the payment for those drugs? Isn't any type of insurance essentially just indemnity? I guess I'm a little bit confused as to why the patient is off the hook if an insurance carrier doesn't pay.
The Act does not favor having claimants pay for treatment. That being said, I don't know that it is entirely clear that they are off the hook, Your Honor. I don't think that's really been litigated in this context.
Well, but let me follow up with that. The Act is clear that they don't favor employees who are injured within the course and scope of their employment and get reasonable and necessary treatment to have to pay for the services that are rendered or the treatment that is given, including pharmacies. But once a determination is made that it's not reasonable or necessary, doesn't that ameliorate that entire notion that the Act doesn't favor the patient having to pay?
I agree with you that once it is determined not to be reasonable and necessary, it's not treatment under the Workers' Compensation Act. And at that point, it's outside of the purview of the workers' compensation authorities who pays for it.
Is it any different than a determination being made that the injury wasn't sustained in the course and scope of employment?
No different. No different. If the treatment's not reasonable or necessary, it's not rendered under the Act, and then none of the Act's provisions apply.
Can I jump in and ask you a follow-up on those questions, counsel? You said two different things here in response to my colleague's questions. On the one hand, you said you could imagine a number of other scenarios. You alluded to something that sounded a lot like subrogation theory, and I don't know if you're telling us that you can envision a contract claim by this patient against, by the pharmacy against the patient, or is it your view, as you alluded to earlier, that this is just the cost of doing business, and this is in effect a reserved loss by these pharmacies? So is it a sunk cost that they're always going to have inherent in the business, or is there a remedy outside the realm of the workers' comp law? Which is it?
Well, I think it could be either, Your Honor, based on the facts of any particular individual case. Not every case is going to have a subrogation possibility or a third-party action associated with it, but some will. So I think in some circumstances, there may be other payors available, and in other circumstances, it may be a cost of doing business. That's something the pharmacy is going, again, that all occurs outside of the Workers' Compensation Act. So your question from the insurance carrier's perspective might be better addressed to Mr. McCoy. But, once it's outside the purview of the Act, it's no longer appropriate for reimbursement through the utilization review process.
It appears that the court passed its questions. Do you have anything you'd like to say to sum up?
Just, Your Honor, that we would request that you reverse the Commonwealth Court to the extent that they made this one sentence holding, altering the utilization review process and providing for notice without even telling us who is to give that notice. Thank you.
You're welcome. Mr. McCoy.
Good morning. My name is Todd McCoy. I represent the carrier, and I just have one quick opening statement, which is the Pennsylvania Workers' Compensation Act is a legislatively created scheme to govern the relationship between an employer and their injured employee. And the problem with this holding is it makes the non-healthcare providers a beneficiary under the Act, which affects how things are litigated and the whole process when it deals with intervening as to how it can end up collaterally attacking or disrupting a UR that took place years ago. So I'll leave that as an opening statement and then address whatever questions you have.
Chief Justice Barra, Ms. McCoy was asked about once it's outside of workers' comp, is it just a pedestrian contract claim? Your client submits the drugs, or provides the drugs. You have an account receivable, I assume. If you're not paid for it, you can bring an action against whoever you provided the drug, in this case, the patient, get the money back. Is that right or wrong?
As to how the pharmacy under the Act, I'm sorry, I couldn't quite hear your full question.
Oh, I'm sorry. Assuming for a second the utilization review says that this medical treatment's not reasonable or necessary. Therefore, as you articulate the Act, you have no obligation to pay for the drugs.
Right.
Right?
Correct. So
I'm trying to think how this would work myself. Go ahead.
So what I would say is this. The purpose of the utilization review process is on what medical procedure is beneficial to the injured worker. It is not a bill recovery process. Reasonableness and necessity, by its very premise, is the medical, whatever's being provided, help the injured worker. If it's not reasonable and necessary, then under the Pennsylvania Workers' Compensation Act, it's not compensable. Now, what we keep talking about with the business model is, and some of the facts weren't developed here, but a lot of these pharmacies, they receive the prescriptions and they start filling them, which is different than if you were to go to a CVS or a Walgreens where you take your prescription, they contact the insurance company, they then tell you either we're going to fill it or you have to make a copay or what's going to happen. Here, there's a different process going on, and there's also some questions which are at a different appellate level as to whether the physicians who are even writing the scripts are also involved with the pharmacies in terms of ownership. So there's a business model going on to ensure that the pharmacies, as soon as they fill a prescription, they're going to get paid. And the argument is that, well, because the UR might find something is unreasonable and unnecessary, we should participate, when the whole focus of that process is on the person who's being treated. And the people who are involved in that are the person who's being treated and the doctor who use their medical judgment to determine the treatment plan for this individual. So if the bills aren't reasonable and necessary, that's the business decision, the risk that the pharmacy runs. And I guess in another context, what I would say is that with medical billing in general under the Act, because we have cost containment. So let's say there's a bill for $100. If under the Medicare codes, that bill is reduced to $60. The medical provider can then go through the fee review and say, well, under the coding, it should be higher. But if it's determined that it's 60, the Act bars balance billing. So any medical provider who treats someone under the Act knows that if it's determined that it's $60, even though we billed it out at 100, we're not going to get that. That's a business risk they know of when they participate in the process.
Can I jump in on that business risk point, counsel? In deciding this case, is it appropriate or is it not appropriate for this court to think about what self-help measures or what self-help measures a pharmacy or pharmacies across the Commonwealth might take in response to a reversal here? In other words, are there consumer unfriendly measures, for lack of a better term, that one might anticipate pharmacies taking in order to protect themselves against a scenario where they're out there providing medicines for years, conceivably out thousands of dollars on an individual basis, and then learn later that they're going to get zero. Is it fair for us, in your view, for us to consider that as we try to decide this case, or is it something that's totally out of bounds in your view?
I would say it's out of bounds for this reason. The workers' compensation scheme was created by the legislature, and they've determined who it is designed to benefit. Again, to go back to what I said a moment ago, the pharmacies are basically saying, because we provided something, we're entitled to remedy under the Act. If we go into the case law under the Act with physicians, if they don't get their bills paid, they don't have standing to file penalty petitions. The claimant does. But now what we're doing is we're trying to change, not we, but the pharmacies are trying to change the process to say, well, when it comes to us, we're entitled to get in and stand in a greater shoes than almost anyone else. And if I were to carry it out with what you're saying, I'm sorry, let me step back before I go too quickly. One, with a lot of these cases, depending on the factual scenario, let's say it's a motor vehicle accident or something else, there may be another insurance carrier involved, which is what my co-counsel alluded to earlier. So there may be another insurance source involved, and that would depend on the facts of the case. But also, when we come back to this context, because of the way billing is done in workers' compensation, bills don't come in on a regular basis. There are some providers that don't submit bills for 6 or 7 months. There are some times when my client doesn't know about these compound creams for a significant amount of time. And what's being said now is, well, even though you didn't know about these bills were generated by the pharmacy, and now they're entitled to go in and reset the entire process because they didn't know. They can communicate with the physician who wrote the prescription. They're involved in the process. And so that's why we keep saying there's a business model going on here because of things that are at the lower appellate level, where there are some physicians who own these pharmacies.
Counsel, just
Mr. McCoy, Justice Saylor, to Justice Weck's point, I think the point is that pharmacies could stop accepting workers' compensation, and that's obviously going to have an impact.
Well,
Everything can say it's not worth the risk. It's not worth the risk.
Well, what I would say to that is that these online pharmacies are more of a recent phenomenon. Pharmacies have been filling prescriptions for work injuries and injured employees for decades.
I understand, but they don't have to. Then if they're not going to get paid, they may not.
Well, normally things are set up and arranged. And what I mean is they're provided with the information, the bills are paid through the pharmacy. That's happened for a significant amount of time. What's sort of changed here is we're dealing with these compound creams and the online pharmacies that are filling these prescriptions. And we're talking about compound creams that are $1,000 to $3,000 that are sent out automatically every month. That's the dynamic that's changed. Not that prescriptions can't get filled, but that there's a new entity involved, and they're saying that, well, because we filled these, we're entitled to payment.
and why, Chief Justice Behr, what, and this is what I was going to ask you before, and I got lost because I couldn't put the pharmacy into place in the question. I apologize for that. But both Justice Donoghue earlier, Justice Weck, and Justice Sayer have all alluded to it. If it's outside the compact, because the utilization review determines that what's occurring between the patient, claimant, and the pharmacy is neither reasonable nor necessary, what precludes, under basic contract law, the pharmacy who has dispensed these creams to the patient, claimant, to sue them for the money? I don't understand.
I don't know.
Workers' comp would preclude that if workers' comp is uninvolved.
I don't know if I could necessarily tell you what would preclude them, because I haven't represented an injured worker and delved into that issue. But I will say this: yes, my client would no longer be responsible, and there would be a determination that the medication was not reasonable nor necessary. But in the UR process, what is assessed is the judgment of the physician who wrote the prescription. These pharmacies receive a prescription and simply fill it. They're not exercising any judgment. Now, how they decide to pursue it, and I can't speak to their own economic analysis and whether or not they're going to write it off, but it wouldn't be compensable under the Act.
All right. And in your view, it's an open question for whatever reason as to whether the pharmacy who provides the prescription to the patient, which may be reasonable and necessary for the condition the patient has, it merely may not be tied to a compensable injury. So in your view, it's an open question whether the pharmacy, it's a question that we should not get into, as Justice Weck said, as to whether the pharmacy can bring the action directly against the claimant patient.
Right. If there was a determination that it was not reasonable or necessary in the UR process, correct. I don't know what they would do at the next step.
All right. Thank you.
Counsel, it's Justice Donoghue. Just one follow-up question on that. What is it in the Comp Act that precludes a provider of medical services like this from looking to the patient for payment? I mean, that would be extraordinary. That would be an extraordinary provision that I think you would have talked about, or someone would have talked about.
Well, the rule in general would be that the bills would not be payable, at least they're not payable under the Act, which I guess I would say a couple scenarios to even add on that. There may be some medical providers, not even just talking about pharmacies, that do not treat injured workers because they don't want to be involved in the process, or they don't want to treat, let's say we're dealing with a claim petition. Claim petition may be in litigation for a significant amount of time. The doctors who are treating these patients, they run the risk that their bills may not be paid. Depending on, if you have someone who's out of work for a year and they litigate for a year and they don't win, then, the doctor decided, I'm still going to treat this individual. But it's different than what's going on here, because here you have a non-healthcare provider, which is saying we're entitled to be in the UR process because we have a due process right. And what my co-counsel said, and what I'm emphasizing is they don't have that right. They're not the beneficiary under the Act. But what they're trying to say is insert us into the Act so that now we have this right and we're guaranteed. That's subtly what's going on here.
Hearing no more questions, is there anything you'd like to say in summation?
No, thank you.
Thank you very much. Mr. Siegel?
Good morning, members of the court. May it please the court, I'm Dan Siegel on behalf of Keystone Rx. What the court has heard in the initial parts of this argument is, one, nothing addressing the legislative scheme, the actual legislation, and a conflation of the different participants and the different processes. As Justice Donahue talked about, we have a non-healthcare provider. We've heard that phrase throughout. And what the court has not addressed or has not even been raised is how this case arose here and where the due process violation occurs. What we have here is a non-healthcare provider, in this case, a pharmacy. It could be an MRI facility. It could be a medical equipment dispensary. It could be a physical therapy facility. Their process, because they are not healthcare providers, is to file what is called a fee review, because the utilization review system under the plain language of the Act only applies to all treatment provided by a healthcare provider. A pharmacy that dispenses medicine is not a healthcare provider. It is, as Justice Donahue said, a medical service provider. An MRI facility that performs an MRI, they follow the instructions of a doctor, a healthcare provider. The healthcare providers have the utilization review system where their treatment can be challenged if it is not reasonable or necessary. Entities, medical service providers, the pharmacies, the MRI centers, they must proceed through the fee review process where their matters are handled through an administrative process. They file a fee review application. What happened here and what happens frequently and where the due process performed of the doctor who prescribed the medicine, the test, whatever. The provider, the service provider, is never aware of the utilization review. They're not a party to it. They have no input. They're not even aware if, in fact, as can happen, the doctor who prescribed whatever the treatment, the medication, even participated and allowed the determination to go through. So because they file a fee review, they are barred from even seeking payment because of a utilization review that was performed without their knowledge, without their notice, without their participation.
Can I jump in, Mr. Siegel? Why does that offend due process if the statute says that the services are not medically necessary? Why and how can your client have an interest for due process purposes? I'm not talking about contract, for due process purposes, given that you're barred under the terms of the statute.
Well, if I'm reading Your Honor's question right, the statute itself only allows for a utilization review of treatment provided by a healthcare provider. It does not provide for review of the services because those entities are performing a ministerial function. And in fact, the Act, consistent with Pennsylvania law, does not include pharmacies, MRI centers, physical equipment dispensaries within that. So they are never even afforded notice that they are entitled to participate, and they have no opportunity to assert their right to payment. So they are being denied payment without notice, etc.
Just a brief follow-up on that. Isn't isn't it the case under the statute, and isn't it consistent with Sullivan to view this as a situation where where the law is entitling the patient to treatment, medical treatment that's necessary and reasonable, but not guaranteeing payments for that treatment? And if that's the case, why isn't your remedy in either contract or some cost spreading device, be it of an insurance variety or some other risk addressing process?
The reason, Your Honor, is twofold. First, going back to Sullivan. Sullivan stands for the proposition that the healthcare provider is receiving due process because it can participate in the utilization review process. That is correct. Those entities receive due process. They receive notice, the opportunity to participate, etc. The entities that we are discussing in this case are medical service providers that do not receive that same remedy. The Act itself doesn't provide for them to participate in that procedure, presumably because they are performing either a dispensary or some other non-diagnostic process. So as a result, Sullivan itself doesn't apply. This is more akin, if anything, to back salary, because in back salary, the worker was denied payment without any hearing. In this case, the pharmacy or whatever the service provider is denied its right under the fee review to challenge it. And while, yes, the workers' comp system is a risk-shifting system, the entities here that are providing services rather than health care are left with no method to either assert or to protect their rights. And that's the distinction.
It's just this. Let me just follow up on this. What precisely would a medical service provider add to the issues being determined in the utilization review committee? The service providers have never made a determination that what they are providing was reasonable and necessary. What do they bring to the table in the utilization review process? Their rights for payment are derivative of the reasonableness and necessity of the prescription that's being given for the treatment by the physician who is part of the process. What would your client do at this utilization review committee hearing?
That's the challenge that we addressed, Justice Donahue, in the Commonwealth Court. And it's the problem that I think the Act actually, if we follow a Statutory Construction Act analysis, the Act addresses it. The Act only, in the definition of utilization review, talks about reasonableness and necessity of treatment provided by a healthcare provider. And in the Act, the healthcare provider is the one who would be denied payment if treatment is not reasonable and necessary. What we have here is the Bureau going a step further and enacting regulations that bring non-healthcare providers under the ambit of a provision only for healthcare providers. I would suggest that the most appropriate method, based on the plain language of the Act, is that the only entities that can be denied payment for treatment are healthcare providers, as it says in the Act, and that those other entities would not be denied payment because they're not providing treatment. They are simply doing, as Your Honor suggests, dispensing medicine, performing a test, etc. So I would suggest that you're correct that the optimum place for participation isn't the utilization review, but what the Bureau should have done, because this is an example of the Bureau abjectly failing to create appropriate remedies, to create an appropriate series of regulations. But what the Bureau should have done was create a process whereby these medical service providers, who are not the entities discussed in the UR provisions, would be notified of the results of a utilization review and would no longer receive payment for future care, but for the medicine they dispensed, for the tests they performed. They would be paid, because there is nothing in the Act that says that any entity other than a healthcare provider would be barred for payment. And the Bureau took a step further in what they did when they created these regulations.
Mr. Siegel, it's Chief Justice Barry. You confused me a little bit. As I read the Act, and specifically 306 F1.5 and F1.6, the scheme as the Commonwealth Court determined it, putting aside whether there's a due process right here for your client to participate in utilization review, is precisely as described. If I understand you, and that is that the medical provider gets utilization review, and the non-medical treatment provider gets the fee review. And the fee review is, again, and I think you know all this. Fee review has to do with one thing: amount and timeliness in utilization review, reasonableness and necessityness. Is that how you read the Act, or do you think that the Commonwealth Court and every court has read the Act wrong, and under the Act your client should have utilization review?
We believe that, I agree with Your Honor's analysis of the language of the Act. I completely agree with that. Where
Can I interrupt you then?
Yes.
Because that's helpful to me. Thank you. If you agree with that, then what this really is a constitutional attack. And that's fine. As I said at the outset, it's Marbury versus Madison. A constitutional attack on the Workers' Comp Act, that it deprives your client of your client pays the $4,000 for the prescription and has no remedy to get it back, in your view, and that deprives you of due process. So the Act is flawed because the Act doesn't give you utilization review.
The Act, I would interpret it slightly differently nuanced. The Act does not create, in this circumstance, a remedy to protect the rights of the medical service provider. It protects the healthcare provider, as it's supposed to do. Our client, the pharmacy, or as I said, all these other medical service providers, do not fall under the definition under the Act of a healthcare provider. Yet they are being denied payment in a process that on its face doesn't apply to them, but given no alternative, because the Bureau's regulation for fee reviews says that a fee review is going to be returned if, among three reasons, the insurer has filed a request for utilization review. That takes the entity, the service provider, out of this picture and gives them no method whatsoever to assert or to be compensated for what they have done, whatever it may be. And in this case, it involved compound medications. It also involved rudimentary, more traditional medications as well.
Mr. Siegel, it's Justice Todd. It seems to me then there are only two possible remedies. One is that you go to the legislature and plead for them to amend this statute, and the other is that you, as Chief Justice Baer said, have a direct attack on the constitutionality of the Workers' Comp Act itself. Those are the two possibilities, correct?
Yes, I mean, from the outset of these cases, and as this court knows, the Commonwealth Court has been addressing these issues extensively, we have asserted that the underlying process deprived entities of due process, that that portion of the act. And while, yes, the ideal remedy is for the legislature to take an inartfully drafted piece of legislation or section of the act and revise it, this court always has the ability to step in and to address where there is a constitutional infirmity.
Mr. Siegel, Justice Saylor, I think you have a remedy. You could ask that the Commonwealth Court be affirmed. That's what I thought you were here for, and then you're fine.
We would accept that. I have, in addressing this court could affirm the Commonwealth Court and allow the.
When in the Commonwealth Court, you won. You got relief, and they created the remedy you wanted.
That's
why aren't you satisfied with that?
We are, but I recognize that there are alternatives that this court could.
Why should we consider alternatives? Well, go ahead. It's your argument.
I am. My clients and I would be fine if this court allowed the Commonwealth Court opinion to stand. It could also create, order a hybrid model. There are various sort of, there's a continuum of remedies depending on how this court interprets it, but we would ask for affirmance.
Can I jump in on this hybrid approach you're talking about here? Because it seems to me there's a schizophrenic aspect to your argument. On the one hand, you go on and on in your papers about how the statute is just fine. It's these persnickety regulations that are the problem. But then I guess at the margin, you're also arguing there is in fact a due process violation. Doesn't have to be one or the other. If it is the case that you want to continue to maintain, as you do in your brief, that these regulations have violated the statute, you're going to have to show us specifically, I think, what is that inconsistency? Because the bottom line for our purposes in the statute is that your client does not have a seat at the table at the utilization review that the General Assembly created. And so I don't know why the argument you're making doesn't belong in the General Assembly rather than in this court.
Well, if I may, and this harkens back to what I said at the outset of the argument. The Act defines a utilization review as solely addressing treatment provided by a healthcare provider. It does not address work done by a service provider, dispensing medication, performing a test, etc. It is the implementation of that provision by the Bureau that expanded the language of the utilization review to serve as a bar to participation or payment to medical service providers that created the constitutional infirmity and is why we are here.
Counsel, can I follow up? I'm going to ask you the question that I asked your opposing counsel. Why can't your client look to the patient for payment?
The client cannot look to the patient for payment because there is a specific provision in the Act and in the regulations that precludes seeking payment directly from the injured worker. And with regard to the pharmacies or the entities subject to a fee review in the regulation, section 127.211 bars such billing. So it is precluded, and it's also in 306 F17 that precludes that type of billing. So they're left without any ability to collect payment.
I truly don't understand that analysis of those sections. I mean, those sections are based upon the presumption that workers' compensation benefits are available. If they aren't, under, I mean, your best argument, if even if they are not compensable by the act, if your client is excluded for looking to the patient, that's your best due process argument. But that's not how my understanding is of how this works. I mean, if the service that's provided is not compensable under the act, then your client would appear to have a right to pursue the patient for payment of pharmaceutical benefits that were provided to them. I mean, if that's the case, I mean, any other way of looking at this, your argument is your client is guaranteed payment under the Workers' Compensation Act. And that is just not the manner in which the statute is structured. No more than claimant is guaranteed wage loss benefits. That's just not how it works. You're a predicate to the compatibility of services or benefits.
Correct. And that is why Commonwealth Court ordered that the Bureau create a process to allow my client to intervene in the utilization review process to protect their rights.
Counsel, Justice Todd, you have a question?
Yes, just in follow-up to Justice Donohue's question and hearkening back to a question by Chief Justice Saylor, it seems to me that the pharmacy's remedy, in a sense, is they don't have to choose to engage in workers' comp claims. They don't have to choose to fill prescriptions in this context. They could choose not to accept this type of client, this type of injured worker, this type of workers' compensation insurance scheme. They don't have to do that, correct?
Yes, but the difficulty is the purpose of the Workers' Compensation Act, the primary purpose is to be able to provide medical treatment and care to injured workers that are able to return to work.
Sure.
If your honors, the basis of the question is accepted, then the act, because all of these entities have no ability to participate in the utilization review, means that not only will patients, injured workers, potentially have an inability to obtain medication, they'll have an inability to obtain diagnostic tests, MRIs, CAT scans, medical testing. They'll have the same challenge to get physical therapy. They'll have the same challenge to get durable equipment. And while yes, you have to balance the risks, the act was not designed to shift the risk of all of those types of care onto those providers without any ability for them to protect their rights.
Well, whether it was designed that way, or not, counsel, that seems to be the present that the General Assembly has laid on your doorstep. Short of getting the legislature to change the law to address the unfairness, which is palpable in such scenarios, why aren't you left to your own devices by self-insuring, by spreading the risk through coverage, by refusing these kind of patients, WC patients, that is, or by pursuing them under some contract theory? I mean, you seem to be coming to us in sort of the modality of a court of justice. And that's really not our role, is it?
Well, this court's role would be to address due process violations, which is the issue here. And in addition, at its core, the utilization review process only applies to healthcare providers, which has been changed by the Bureau's regulations in a manner that created this due process violation. But this court always has the ability to address due process violations. That law goes back, as the Chief Justice said, to Marbury versus Madison.
Mr. Siegel, Chief Justice Barrett, and your time is short. I wanted to reduce this to the root. Your contention is that there's a deprivation of due process in the act, in the regs. Obviously, there's no life or liberty interest. So you have to claim a vested constitutionally protected property interest. It seems to me, much like Justice Weck said to you, that you're a business that extends credit and has an account receivable and has an expectation of payment. But I don't see where you're unique from any other business where you make the decision to do that. You'll have some losses, you'll have many more gains, or you'll get out of business. But I just don't see where your expectation is a constitutionally vested interest.
That, Mr. Chief Justice, goes back to the Sullivan case, where the Supreme Court found that there was no deprivation in the utilization review process because the medical care providers had the ability to participate in a utilization review before they were deprived of their right to compensation for treatment. When you apply that in this case, that same protection does not apply to medical service providers. So where the Supreme Court found that the Act did protect due process, did provide due process to medical care providers, that same analysis fails for clients such as mine.
Any further questions from the court? Thank you, Mr. Siegel.
Thank you.
Case under advisement. We're going to take a 5-minute break to allow our staff to have these counsels go about their day and to get new counsel in. So we'll stand in adjournment for just 5 minutes. Recess.
Consolidated School District versus the Chester County Board of Assessment and Appeals and Autozone. Representing Autozone is Ms. Sharon F. DiPaolo. Representing Kennett School District is Mr. Scott R. Withers. Representing Chester County is Mr. Anthony M. Brickta.
This case involves a constitutional challenge to a school district's method of determining which property assessments to appeal. Appellant contends that the school district violated the Uniformity Clause of the Pennsylvania Constitution by employing a method that subdivides real estate in the district based upon both a monetary threshold and a particular type of real estate, here commercial versus residential real estate. The school district and the county board of assessment argue the assessment decisions comport with the Uniformity Clause. This court accepted review to explore further Uniformity Clause issues in tax assessment cases after our relatively recent Valley Forge decision. If I got that pretty close to correct, Ms. DiPaolo, you're arguing for appellant. Introduce.
Thank you. Thank you, Your Honor. May it please the court, my name is Sharon DiPaolo, and I represent the appellant, Autozone Development Corporation. To meet the constitutional mandate to the taxing authorities that all taxes shall be uniform upon the same class, requires that the object, the measure, and the method employed by the taxing authorities are uniform. Only if all three are present can there be uniformity in the tax burden. In Cope's estate, this court faced for the first time the issue directly before the court today, and the court answered there definitively that a tax threshold based on the size of the estate is unconstitutional. Since that time, the General Assembly and its political subdivisions have repeatedly attempted tax schemes which tax some on different measures than others, and each time this court has struck down the scheme. Most recently in Nextel, this court said classifications based solely on the quantity or value of the property taxed are arbitrary and unreasonable. Because all real estate is one class, the test is straightforward, namely to examine the effective tax rate of two similarly situated properties when the tax scheme is applied. Here, applying a $1 million threshold, assume two properties, both of which have an actual value in the marketplace of $2 million, the first of which is currently assessed at $1 million fair market, and the second of which is assessed at $1.1 million fair market. Applying the threshold, the first property would be appealed, raised to $2 million, and pay an effective tax rate of 1.9%. The second property would escape appeal, pay on $1.1 million, and pay an effective tax rate of 1.1%. Two identical properties, both worth $2 million in the market, yet one's effective tax rate is nearly double that of the other, all because of a facially neutral scheme which sets a different measure for the taxation. Only when the object, the method, and the measure are uniform, and under a principled application of the doctrines, can we achieve constitutional uniformity in taxation.
Mr. Paulo, it's Justice Todd. According to the Commonwealth Court, that the decision that they made, this was not a deliberate target to a particular class, but rather the purpose was making a prudent financial decision. Do you believe that's just pretextual, that approach? What are you saying here?
Yes, I hear two questions there, Justice Todd. One is to the cost-benefit analysis that the Commonwealth Court was influenced, which is the school's rationale, and then also whether the school's rationale is a pretext.
Yes.
In answer to the pretext question first, what we are seeing is that actions speak louder than words. So rather than allow a taxing district to hide behind a facially neutral scheme and say, don't look at the impact or operation and effect of those that we are appealing, the Commonwealth Court is allowing school districts to not have a policy in writing. That's in the Punxsutawney case where they said that this court didn't require that the policy be in writing. They're allowing policies to be enacted 5 years after the appeal was taken. That's the Commonwealth Court's decision in Colonial School District, May 2020. And they're functionally requiring the property owner, allowing school districts to hide behind self-serving statements that say, we meant to include houses, we just didn't find any. As respect to the cost-benefit analysis, the Commonwealth Court in the case below, in this case, called it abundantly clear that this court and in Valley Forge allowed a balancing between a school district's cost-benefit and the requirement of uniformity. That's not consistent with this court's holding, both that uniformity is the preeminent principle, and also if we look to the Salisbury decision of this court, that rationale, the cost-benefit, was squarely addressed and rejected by the court as a balancing against uniformity.
Thank you.
Well, counsel, could I follow up on that question briefly? Valley Forge is a very different case. I mean, the taxing body there set out only to tax commercial entities. Here, they told the guy, go out and give us properties that are underassessed. I don't understand the reach of your argument because and the facts have to be construed against you, right? Because this comes up with you as the move-in at summary judgment. How would we treat a reverse scenario where Mr. Lukens had got out down Millionaire's Row and seen 13 properties that he and his expert view felt were likely to be underassessed, substantially underassessed, and go after them? I mean, isn't it the case that writ large the taxation paradigm is best served when anybody, be it taxpayers or school districts, bring an appeal?
With respect to the question about how they selected appeals and the distinction on the facts of Valley Forge, here they appealed 12 properties, all highly valued commercial properties. That's in the record at 185A. And there are 9,500 properties in the district. So it makes no matter if it's 12 millionaires or 12 commercial property owners. Either way, the effective tax rate is going to be higher for the 12 properties that they appealed. For equally situated properties, similarly situated properties will be paying different effective tax rates depending on whether they got picked or not picked by the school district for appeal.
Councilor Justice Donahue, maybe I misunderstand what your argument is or was, but I thought that your argument was premised on the notion that there was disparate treatment between commercial and residential properties. Is that not what your argument is?
That is an argument as well, Justice Donahue. Our argument primarily is that they have selected based on a monetary threshold, which is set forth in their consultant's email that says all properties that are underassessed over $1 million. The facts of the case are that they also only appealed commercial properties. We believe that the lower courts and the Commonwealth Court have narrowly construed Valley Forge to mean that it's okay to appeal commercial so long as you consider appealing residential.
Well,
and we think that, yes.
On this, because coming into this argument, I was really working under the impression that your disparate treatment claim was based on the commercial versus residential classifications of property. And let me just follow through on that, because I think that's what your argument is. I think that's the way that the Commonwealth Court addressed this case. How do we know on this record that there were any residential pieces of property that were excluded from this assessment process?
Mm-hmm.
Isn't it your client's burden to come forward with that evidence of disparate treatment?
Your Honor, based on the actions speak louder than words, here where the school filed on 12 properties, all of which are commercial, their own actions demonstrate that they selected commercial properties for appeal.
But that's just not true. Action speaks louder than words doesn't answer the evidentiary question. Where is the evidence that there were any residential properties within this taxing district that fell within this criterion?
That is not in the record, Your Honor.
Isn't that your burden to establish that there were such residential properties in order to prove that there was disparate treatment between residential and commercial properties?
I think that it places an unfair burden on the taxpayer to have to prove out what the school's selection scheme is. That as a matter of public policy, since the school has a constitutional mandate to implement its policy uniformly and transparently, it should tell us what the policy is. And once we demonstrate an operation in effect that the policy unfairly treats one class or subdivides the class, the inquiry ends and the burden shifts to the school district to prove that its policy is not, that they did not implement their policy in an ununiform manner.
Counsel, Chief Justice Behr, Justice Wecht mentioned that this is here from summary judgment determination. Is that correct?
It was a motion to quash or motion to dismiss.
That's how I do recall that it was a motion to quash. And the trial court, in its opinion, quoted from the school district consultant's email, the email to the consultant, which said, give us advice as to what is the most under-assessed and sufficient to justify cost and expense of taking such appeal. Now, what you're really saying is you disbelieve that. Is that fair?
Well, the consultant also said, I recommend that you appeal these 12 properties that are underassessed by $1 million.
So is your argument that you have a genuine issue of material fact as to whether the school district is doing their assessment based upon the most underassessed or dividing it, properties worth $1 million or less than $1 million, and you want to try that fact?
The email that you referred to, the consultant or the school manager says, appeal the most underassessed properties without regard to class. That self-serving statement, or the schools mentioned in their brief that we appealed some properties that were underassessed, if schools are allowed to refer to a policy that's that loose, we can never enforce uniformity. So, but that's why I look to the operation effect of what they actually appealed.
Ms. DiPaolo, again, I'm not sure procedurally on summary judgment or on a motion to quash whether you have an issue or not have an issue. As Justice Don who said, you have to bring up evidence to create a genuine issue. Will you agree that if this is if a trial court after a full hearing determines that the assessment occurring here is based solely upon what is the most underassessed property, that does not violate uniformity?
I think we need to have a standard for what the most underassessed is. I think if we allow schools to have a loose standard that says we appeal some but not others in Punxsutawney, I know it when I see it, that's not a standard at all.
But counsel, therefore, aren't you saying to us that therefore school districts have to appeal every property in their bailiwick, in their catchment area, or none? Because other than that, you don't accept any criteria?
No, Your Honor. In Clifton, this court laid out 3 options for school districts and rejected that the only option to them is to appeal all properties. And the options are a proportionality principle, raising millage rates, or asking for a countywide reassessment.
That if Mr. Lukens had continued driving and happened upon a really wealthy neighborhood and sent an email back to the district and said, I think these 13 are likely to be under arrest by more than by more than $1 million of market value. Would you be standing in front of us and saying that is a uniformity clause violation?
Yes, setting a monetary threshold, a bright line in the stand, is a uniformity violation because it sets different effective rates for people just under and just over the threshold, just as in Maldari and just as in Nextel and other cases in which this court has evaluated the effective tax rate when a line in the sand is drawn.
Well, wait a minute. I think you're improving on your record at summary judgment or on motion here by suggesting that the trial court used a bright line standard. And you're doing so on the strength only of an email here. Does your argument necessarily have to be that there is no cost-benefit analysis allowed to taxing bodies? They're not entitled to undertake reassessment efforts that they think will bring them more revenue, allowing them to keep taxes down district-wide?
If the school district's policy is based on the proportionality principle, I think it stands. But using the cost-benefit analysis as their explanation for choosing some or not others, I don't think stands under this court's precedent. I think it succumbs to the uniformity requirement and the hierarchy of the Constitution.
But Chief Justice Berrigan, but really, generally we decide questions of law, and I know you're skirting around them, but you really have a basic factual dispute. What you're really just saying to us is, my client doesn't believe the school district when the school district says we based our assessment on most underassessed. That's the sum and substance of your argument. You're not really fighting about the law. Is that unfair to you?
On the record of the school's own statements from the own evidence that went in unrebutted, the school asked the consultant to look at all the properties that are underassessed, and the return that they got is properties under $1 million underassessed, and the school adopted that on the basis of the recommendation of its agent. So I think that is the school's policy by its own actions.
But the trial court disagreed with you. But the question is, did the trial court have before it a record sufficient to permit it to disagree with you? And that's all this case is really about.
I think that the school has to be held to the actions that it actually took, as opposed to the actions that or the statements that it makes after the fact about what it meant by its policy.
Well, you want there to be, you want us to surmise from this incomplete record that there's clear evidence of pretext. I guess basically just on the strength that the output was 12 commercial properties. So I guess you're saying the court has to jerry-rig this thing to say if you don't have 5 commercial and 5 residential in any one group of 10 appeals, you've got a uniformity violation. I mean, that seems to me to be breathtakingly ambitious holding for the court to undertake. Wouldn't that handcuff taxing bodies?
Yes, I don't expect a bright line, 2 is enough or 3 is enough. But if their policy is applied proportionally, it should be drawing in residential and it should be drawing in commercial. It should be drawing in high value properties and low value properties. It should be based on a proportion of how far off the property's assessment is as compared to the market, as opposed to a bright line standard.
Mr. Paulo, at base, your argument is, as I understand it on the record, that the school district adopted a policy recommended by their consultant to undertake these appeals, and he said that he had selected or targeted properties with a high probability of being underassessed by more than $1 million in market value. Is that correct? So
yes.
The school district created a class of properties that they were going to go after. Is that correct?
Yes,
And that's your argument that that's impermissible. And secondly, on your appeal to the Commonwealth Court, you challenged not only the fact that these ended up being only commercial properties, but that adopting a monetary threshold that effectively targeted only those properties with an actual market value of over $1 million for assessment was impermissible. When we know that, or you say that, and I think it's true, you've created a class because it's mathematically impossible for any property with an actual market value of less than $1 million to be underassessed by more than $1 million. Isn't that correct?
yes,
So they're creating a class of properties that you're targeting. And I understand the reasons. I'm not saying let's go after the properties where we can make the most money by spending the least amount of money. But your argument is there's an impediment. It's called the uniformity clause.
yes, Your Honor.
Thank you.
Thank you very much, Ms. DePaul. Assuming nobody has any further questions, that's the appellee. Again, this is a case where two counsel are going to divide their time. Please do not be repetitive. Whoever's going to introduce yourself.
Chief Justice Bayer, honorable justices, may it please the court. Scott Withers of Lamb Macra Lane on behalf of the appellee in this matter, the Kennett Consolidated School District. School district will heed Chief Justice Bayer's instruction given at the outset not to pile on. The school district will address the uniformity arguments of the appellant, and Mr. Brichta, on behalf of the Chester County, will address the board's position and the practical effect of the relief requested on the tax assessment system as a whole. Your honors, the school district created no class in this appeal. The school district has not divided real estate into two subclassifications of property, as taxpayer alleges. The entirety of that argument is based on a reading of the email from Mr. Lukens. That is Exhibit T2, Trial Exhibit T2, at 185A in the record, where Mr. Lukens writes, the following is a list of properties which we think have a high probability of being underassessed by more than $1 million of market value. Appellant, the taxpayer, believes that this establishes that the school district divided the real estate into two subclassifications of property. That is pure speculation. The email did not say we considered only properties with actual market values of more than $1 million for potential appeals, assessment appeals. That's not what that email says. The only way you can find that the school district created two classes here is to speculate as to the meaning of that email.
Well, Mr. Withers, let me ask you this then. How would it be mathematically possible for any property with an actual market value of less than $1 million to be underassessed by more than $1 million?
I don't think it is possible.
Well, that's a class.
Justice Saylor. But that's an assumption that this sentence, which can be construed as an observation, it can be construed many different ways. But that's a speculation that this sentence means he divided it into two classifications, and that was his selection methodology. That sentence says no such thing. And the way for the taxpayer to have established that would have been to call this witness and ask him what that meant. The taxpayer didn't do that. And Justice Wecht, as you said, this is a case where the court is being asked to surmise from an incomplete record that there was some kind of discrimination. The record on the uniformity claim in this case is completely deficient. It consists of 3 emails and a little bit of testimony. And Chief Justice Bayer, to answer your question earlier about the procedural posture of this motion, a pretrial motion to dismiss was filed by the taxpayer. Because no precipice was filed in the trial court, that was never ruled on pretrial. So at the beginning of the assessment trial in this matter, the trial court asked the taxpayer if they had any evidence to put on in their uniformity case. And the sole evidence they presented were those 3 emails. This is a completely deficient record to find a violation.
Mr. Withers, it's Chief Justice Bear again, and I'm just following up to make sure I understand it. The trial judge here was Judge Schenken. Is that correct?
Correct, Your Honor.
In fact, an evidentiary hearing before Judge Schenken. Is that correct?
Correct.
Because you mentioned P2 as a trial exhibit, so there was an assessment trial.
Yes, Your Honor.
Okay. And therefore, Judge Schenken, to some extent, in fact, maybe to every extent, has made a factual determination rejecting, and tell me if, I guess it's a softball, but just try to tell me if I'm right or wrong, if you would, rejecting that the $1 million was a class and rather accepting the email that I referenced earlier to Ms. DiPaolo, in which the school district said no, specifically request from the school district to the consultant. So the school district said, look at this only as a matter of what's underassessed, most underassessed. So we don't have he said, she said. We have a factual finding by a trial court. Is that correct?
I would agree with your recitation, Chief Justice Beyer, yes. And on that record, we don't have a record that a school district has treated subclassifications of property differently as prohibited by Valley Forge or this court's jurisprudence.
Now, finally, and I don't want to dominate this, but I think Mr. Paulo made the argument that once there's a question as to whether or not there's skullduggery afoot by the school district, $1 million or not $1 million, rather than
acts of the General Assembly are presumed to be constitutional. The statutory grant of authority here is contained at 53 PACS 8855, which authorizes appeals by school districts. That's presumed to be constitutional. And as stated by this court in Fisher Controls in 1977, a taxpayer complaining that administration of a tax violates its right to be taxed uniformly with others in its class must demonstrate deliberate, purposeful discrimination in the application of the tax before constitutional safeguards are violated. So here you have a taxpayer alleging the statute is unconstitutional. And I'm not aware of any constitutional challenge to a statute in Pennsylvania where the burden is on the state actor to prove that the statute is not unconstitutional. That throws things on their head. I respectfully submit it was the taxpayer's burden at trial when raising a uniformity claim to present sufficient evidence of that claim to carry their burden of proof.
Mr.
And then you possibly have a burden shift.
Mr. Withers, Justice Saylor, again, though, stepping back and looking at the scheme, without getting, which is just it's a broad-based attack on this notion that the school district undertook this process. But forget about the properties over $1 million. The directions that I understand was to review all classes of properties, including commercial, residential, and otherwise, for purposes of identifying the most underassessed properties to justify the cost of an appeal. Is that correct?
Yes, Your Honor.
Now, is that creating two classes? The most underassessed. So my house may be underassessed, but it's not the most underassessed. So you're going to now have, per face, forget the justification, different classes of taxpayers in that school district. There has to be then some criteria, and you can argue about what it was, but they're saying set up a line, the most underassessed. So if I'm a taxpayer, I may not fall into the most underassessed. I'm just underassessed. But it seems to me that when you're looking at the uniformity clause, what it says is you have to treat all taxpayers uniformly. So you're treating different taxpayers disparately, aren't you? Depending on whether their property is the most underassessed.
Well, if that's the law of the Commonwealth, then cost-benefit analysis is never going to pass constitutional muster.
There's nothing wrong with the cost-benefit analysis because they're saying, look, we don't want to, we want to make this cost-effective. I understand that and I appreciate that. So we're not going to do a county or a school district-wide reassessment. It's going to cost us a lot. we're probably not going to target a property that's underassessed by 50,000 because it's not going to be there, but you're creating two classes. The most underassessed, what does that mean?
Well, I think we have to read that whole sentence, Justice Saylor. It's the most underassessed and sufficient to justify the cost and expense of taking such an appeal. And that's how I would draw the distinction.
Thank you.
To address the burden of proof and the subclassification argument, the only other thing is the argument that this is unintentional discrimination, that this is akin to a disparate impact case. And we think that fails because we don't have two classes here. And the school district is not systematically excluding residential properties for appeal. Justice Donahue, it is taxpayers' burden here. And we don't know on this record that residential properties were excluded. And the reason we don't know on this record is because the taxpayer didn't build a record sufficient to answer that question.
Counsel, can I stop you there? If I'm not mistaken, the record 36A and 53A, the basis for the lack of the record is your client's refusal to answer. When they asked why you scheduled or why you chose those properties, you refused to answer in discovery. And now you keep using your refusal to answer to attack counsel's position, which is supporting former Chief Justice Saylor's argument that you've developed a class, and you're arguing against that without telling us. So tell us, what was the basis for this assessment?
Justice Doherty, I believe there's a possible misunderstanding. The school district did respond to the interrogatories. They didn't refuse to respond to discovery. The issue is that none of the discovery responses, although they were possibly admissions, or they were admissions by the school district, were never entered into evidence in this case. They're not part of the record. That's the problem. The school district's the taxpayers' interrogatories and the school district's responses are not part of the record before this court. That's why. And so that, it's not that we didn't answer them. We answered them. The school district is being we. We answered them. They're not part of the record. The sole record in this case are those 3 emails. And that's the problem.
Counsel, Justice Donahue, let me follow up on this burden of proof issue, which is sort of an issue in this case that could, regardless of other things, have a longer lasting effect. What is it, in your view, that the taxpayer had to establish in order to shift the burden to the school district? I mean, their position is you pick the monetary threshold, that's what you used, and the results were that there were only 12 assessment appeals, and they all fit within that monetary threshold. What else is it that you would have had the taxpayer come forward with in terms of evidence in order to shift the burden to your client?
I think that they would have to show that the school district had a program of appealing the assessments of one subclassification of properties drawn according to property type, which they didn't do here.
But getting back to Justice Saylor's earlier questioning, the classification was properties with a value in excess of $1 million. Why isn't that fact established on this record?
That fact is not established on this record because it's based on a single sentence from Mr. Lucan's email in Exhibit T2 that does not say what the taxpayer is purporting it says. It does not say that the basis upon which Mr. Lucan's determined what properties to recommend for appeal was their probability of being underassessed by $1 million. That sentence taken in isolation doesn't show that.
And how about that sentence in conjunction with the fact that the 12 appeals that were taken involved properties that had a value in excess of $1 million? Doesn't that get them where they need to go?
I do not believe so, Your Honor. They do not have, there's no linchpin holding that together. There's no evidence that that was the methodology that this consultant used. It's just as possible that he's making an observation. The following is a list of properties I think have a high probability. Is that the standard that he used? We don't know. And the only way we could know is had taxpayer called witnesses, had actual evidence that could establish the taxpayer's burden here. And on this record, you have no such evidence.
Mr. Withers, Chief Justice Behr again. Maybe I'm missing something, but it just seems to me that this kind of factual dispute is decided by the trial court. Here, the trial court decided it in your favor, but if the trial court had decided it against you, if the trial court had said, yes, in looking at this evidence and in listening to the witnesses, I think that the school district, in fact, is engaged in subterfuge. There was a criteria here. They were only appealing properties $1 million with a value of $1 million or up. Don't you lose the case?
I think so, because then you're saying, Chief Justice Behr, is the trial court has determined that the school district has implemented a program of only appealing the assessment of one subclassification of properties. And here you don't have such a finding. And I don't think you can get to that uniformity conclusion that there's been a violation of the uniformity clause on this record.
All right.
Taxpayer here.
Just to follow up, in response to Chief Justice Behr's question, we would have a very different procedural posture here had Autozone called Mr. Lukens as on cross and said, why didn't you bring us any of these properties from Millionaires Row a quarter of a mile away? And had he responded, well, I thought commercial properties were the way to go here, you'd have a problem, right?
I would have an enormous and probably insurmountable problem, Justice Weck. It was posed to the other side. Isn't this a case that the taxation paradigm is best served by the assessment appeals process? And I would say yes, Justice Weck. Individual appeals, whether by a taxing authority or an individual property owner, always enhance uniformity by lowering the coefficient of dispersion, which is the variance from the common assessment ratio in the district. So all assessment appeals enhance uniformity. It's the failure to appeal which perpetuates non-uniformity. And that's what the taxpayer is trying to effectuate here, is they want to kick this a tax assessment appeal and perpetuate non-uniformity in the taxing district. Nothing on this record shows that residences are underassessed in Kennett Consolidated School District or that residents weren't considered by the consultant. And the school district would respectfully request that this honorable court affirm the order of the Commonwealth Court. Thank you very much for your time.
Mr. Bridgestone, case has been well argued. Add anything you'd like to add.
Good morning. May it please the court. Very briefly, Anthony Bricht on behalf of the Chester County Board of Assessment Appeals. I just wanted to make two brief points. One, there were some questions on the record in this matter, and it is fairly unusual to have a record that's this sparse. I mean, the board hears and is a party to all of the uniformity challenges in Chester County. We typically will see witnesses called. We sometimes have requests that are typically granted for a separate evidentiary hearing, which precedes the valuation trial on a separate date. We've had experts called as to uniformity on behalf of a taxpayer. So the types of questions on the record that the court has are good, and they usually are fleshed out before the trial court. That wasn't done here for the reasons that have already been discussed, and I do think it's the taxpayer's burden to bring a full record to the court. Our primary point, being a party to each one of these uniformity claims, is that similar to what Justice Wecht had questioned earlier, which is right now you do have a sort of a balance in the system, in that you have taxpayers who are well equipped when they believe that they're paying too much, that they're overassessed, to file challenges on their behalf. And on the flip side, you have school districts that are able to identify properties that are severely unassessed and bring them back to market value. And the system generally works pretty well right now. You get to a closer market value, you get a value that equates to what the property is actually worth. The board's concern in terms of this assessment system as a whole is that the relief that's being requested doesn't really set forth a workable standard. If a school district's not able to consider the amount in controversy, if they're not able to consider their own costs, they're going to be effectively severely curtailed or precluded from filing assessment appeals in almost any cases. As someone made the point earlier, they're going to effectively be pushed to appealing all or none of the appeals. That's not going to promote uniformity. That's going to disrupt the tax system, and we're going to have an assessment system where it's basically one-sided, where one side of the equation can file an appeal when they think it's too high, but there's no mechanism for anyone to challenge it when the assessment's too low. That's not going to promote uniformity. That's not going to help fairness in the county or in the Commonwealth as a whole. We think that's probably why you see so many amicus briefs filed in this matter, from Philadelphia School District to the Pittsburgh School District and smaller school districts in between, and that there is a real concern, particularly with how sparse this record is, that if the court were to grant any relief to the taxpayer, it would unnecessarily upend the tax system as a whole, and really make the system no longer workable. So with that, we would ask the court to affirm the Commonwealth Court's decision.
Any questions at all from the justices? Thank you, Mr. Barta. Again, as I said, well argued by all. We'll take a 5-minute break again, and then we'll do our third case for the morning.
The next argument is Greenwood Gaming and Entertainment versus the Commonwealth of Pennsylvania. Representing the Commonwealth is Mr. Michael Sorenci. Representing Greenwood Gaming is Mr. Mark S. Stewart.
There, I had some difficulty unmuting. In this case, the Commonwealth challenges court's order reversing the Pennsylvania Board of Finance and Revenue's denial of a tax refund to Greenwood Gaming and Entertainment, Inc., related to Greenwood Gaming's distribution of concert and event tickets to patrons at Parks Casino. The question presented is whether concert and event tickets distributed by a casino to patrons as a result of playing table games and slot machines could be deemed to constitute services for purposes of Section 1103 of the Pennsylvania Racehorse Development and Gaming Act. If the tickets are deemed to be services, the casino cannot deduct the expenses incurred from its gross table game revenue or its gross terminal revenue for purposes of calculating related taxes. Conversely, if they're not services, the expenses incurred in supplying these tickets are deductible by the casinos. Mr. Scarnacci, did I pronounce that correctly?
Scarency.
Scarency, I apologize and thank you. Feel free to proceed.
Thank you, Mr. Chief Justice, and may it please the court, Michael Scarency for the Pennsylvania Office of Attorney General on behalf of the Commonwealth. The Commonwealth Court erred when it concluded that a casino was not distributing services to its patrons when it gave them free admission tickets to see concerts and shows with performers like Cher and Jay-Z. My adversary seems to think that we've conceded that admission tickets are personal property, but our position has been consistent. We argued to the Commonwealth Court that it should affirm the Board of Finance and Revenue's conclusion that it is, quote, the nature of the items or the services involved that determines whether the cost of the ticket is deductible. And we've consistently maintained that there's a distinction between the tickets themselves and what they convey or represent. That's the same argument we are making here to your honors, and certainly my adversary is not arguing waiver or law of the case. But even if this court concludes that admission tickets are personal property, that is not dispositive. The court still has to answer whether a service is being conveyed. An examination of Section 1103 bears this out. Section 1103 allows for a deduction of, quote, any personal property, but then modifies that by excluding from the deduction food and refreshments. For example, coffee beans are certainly personal property. They are even traded as a commodity. But if a casino started handing out bags of Starbucks coffee beans, that would be excluded. Coffee beans are both personal property and food. Even if an admission ticket is intangible personal property, although for reasons I'll explain later we believe it is not, it conveys a service and so must be excluded from the personal property deduction. Now, there are several reasons why admission tickets constitute services. First, although the Gaming Act does not define services, that term is unambiguous. Courts around the country, including several state courts of last resort, have all concluded that when an admission ticket is sold, whether it be to a baseball game, an amusement park, or a boat ride to Alcatraz, what was being sold was a service. Second, admission tickets are some of the most common comps that a casino distributes to its patrons. Nearly all of these out-of-jurisdiction cases cited in our main brief predate the Gaming Act, some by decade.
Can I jump in there, counsel? I think we gave you 2 minutes. I have a question on that. You're talking about comps. Well, the legislature knew how to address that, didn't they? Elsewhere in the Act, under junkets, they included entertainment. Here, they expressly included, quote, entertainment, unquote. Here, they expressly did not include entertainment, but instead used the undefined term services. Why isn't it just as plausible? And if ambiguities, have to be construed, of course, in favor of the taxpayer, why isn't it just as plausible that services didn't include entertainment, because that's defined elsewhere, but included maybe they were thinking of spa services, for example, which a lot of these places offer. Maybe they're thinking about golf. I don't know, but what they're thinking. But isn't it just as reasonable to surmise that since they didn't include entertainment here and included it elsewhere, that they were not including the tickets for Justin Timberlake or what have you?
Well, as you alluded to, I think services is broader than just entertainment. I think they had in mind some of the many different kinds of services that a casino might offer, like spa services, haircuts, nail salons. I know some casinos even offer childcare services. So I think their intent was to use something broad to capture a lot of the things that a casino gives away on a regular basis.
Council,
yes.
this is Justice Donahue. The definitional section of the Act also defines complementary service. When you and your opposing counsel agree that what the legislature was attempting to capture in this exclusion was comp services that are comped or comps that are given by the casino, is the agreement that what the intention was to exclude complementary service as that is defined in the Act. The Act defines complementary service as any lodging, service, or item, which is provided to an individual at no cost or at a reduced cost, which is not generally available to the public under similar circumstances.
I don't think we briefed the definition of complementary service in our briefs.
Is that what you mean by comps? That's what I'm trying to get at. I mean,
I think comps could be discounted or free. I think it's either one. I don't know if I entirely answered your question. If there was another part to that.
Is there an understanding as to what comps are? Because there appears to be an understanding between the parties here that what is being excluded in section, the section that we're talking about are comps that are handed out by casinos.
Correct. I think, yes, anything that a casino hands out as part of playing a table game or a slot machine, that would be a comp, something that's either free or discounted.
But doesn't that get us to a factual question here that I'm just not sure is answered on this record? If what the legislature was attempting to encompass in this exclusion were complementary services as that is defined in the Act, what do we have on this record to establish what comps are in the trade?
We have the stipulation of facts. We also have the exhibits that were attached to it that included a lot of different things, both things that were covered that the Commonwealth didn't challenge and things that we did. I think they received almost $1 million deduction for lots of different things like handbags and iPads. I don't think there was any dispute as to whether these were given out as either free or discounted. And again, it includes a wide range of things.
Yeah, but that's where I'm struggling with this. And I have to tell you that this case has me stumped because what you're saying is the Commonwealth decides what a comp is. And to me, what a comp is a factual issue that's given definition in the industry. I mean, I don't have a hard time accepting the proposition that tickets to a concert may or may not be a comp, but I don't know that. I mean, a complimentary service is any lodging, service, or item which is provided to an individual at no cost. Had we not had thrown into this mix, this stipulation between the parties that what was intended to be captured here were comps, I wouldn't be going down this line of questioning, but there is apparently some agreement that that's what the legislature was attempting to accomplish here. And the Commonwealth saying it's a comp doesn't make it a comp, nor does a casino saying it's not a comp make it not a comp. So I'm really sort of struggling with the parameters that we're dealing with here.
Well, I think it goes back to the commonly understood meaning of the term. The same with services. It's something that's given away for free or discount to the patrons. And I think the casinos have a lot of leeway in terms of how creative they can be as to what's free, what can be deducted or not. Again, I mean, it's
sunglasses. How about if the casino regularly gives Gucci sunglasses?
Well, sunglasses would be personal property.
But it could be. But it could be a comp. See, that's the problem I'm having here with the manner in which this issue has been framed.
Mm-hmm.
If the legislature was attempting to exclude comps because they didn't want the taxpayers in the Commonwealth to bear the burden of those comps, I don't know how we decide what that term means in the industry in Pennsylvania. I just, a service could be many things.
I agree. A service could be many things. I think if you want to compare and contrast between what's a service and what's personal property, I think some examples can showcase the difference. The difference between between personal property and a service is human labor or effort or skill. If you think of like a bank certificate, a stock certificate, which involves the value of all the tangibles and intangibles of a company, or you think of a bank account, which is a promise to repay, or an insurance policy, which is a promise to pay money upon the occurrence of a specified event. None of those involve human labor, whereas if you're talking about a nail salon or hairstylist, spa services, or entertainment events, those all involve human labor, skill, or advice.
Can I ask you a question on that, counsel? Suppose you give me a ticket to a Timberlake concert. Putting aside, I wouldn't attach great value to that personally. What prevents me from negotiating that? I mean, why can't I just? There's no non-transferability provision here. Why isn't that personal property if I can sell it to somebody for value?
I think it goes back to the overarching approach this court takes in tax cases, which is to deal with realities. I think most people.
You're asking us then to just rewrite the statute to conform with our notion of, quote, reality, unquote. Aren't we locked into what the General Assembly said here, which is services, and having to construe what that means rather than sort of doing the right thing?
I think it would be what was generally used for. I mean, most people don't take a ticket and give it away or put it under glass, as my adversary has said. The value is actually in going to see it.
You haven't been on
the fact that it's transferable.
You haven't gone to StubHub recently, then.
Yeah, I mean, the fact that it's transferable, I think, is not. I understand that it's transferable and that a person could use it to gain cash. I think we're looking at the overarching, how it's intended to be used, which is to reward the person who received the ticket.
Mr. Scarinci, may I ask you a question? Under your analysis, is there any difference between the casino putting on a concert or a performance of its own inside the casino and telling everyone in attendance at the casino, you're welcome to attend the concert, and what we're talking about here, off-premises concerts at some arena where the casino's giving out tickets? Is there any difference in those two things in terms of services?
I don't think the statute makes that distinction between being the service provider and allowing someone else to provide it. I know the Commonwealth Court majority made that distinction, but again, I think there's no distinction in the statute, and I think that would be a way for the casino to avoid the tax or evade the tax by simply hiring a third party to do it, or having they could put a barber in the casino, and as long as that person's an independent contractor, that would allow them to avoid the tax. And I don't think that's what the General Assembly had in mind. when they created this this personal property deduction.
I'm sorry. Go ahead and finish your.
No, I finished that thought, Your Honor.
This is Chief Justice Fair. Just as an aside, I thought that the digression into what type of property this was pretty useless, respectfully, to the disposition of the case. There's three kinds of property in the world, and that's all there are: real property, tangible personally, and intangible personally. There's no question these tickets are intangible personality, just as a $1,000 bill or a stock certificate, as you said. But I don't think that helps us to answer the question. And there's no such thing as intangible services. The question here is whether or not services include these tickets. So that's just sort of an aside. Get that off my chest. It seems to me. Are you familiar with the statutory construction precept of Keystone generis? That when you have a list of the specifics and then the general follows that.
Correct. Yes, I'm aware.
So the legislature, that's been around for 1,000 years. The legislature could have said travel expenses, food, refreshment, lodging services, and the like, and all other comps. And they didn't do that. So Keystone generis doesn't work as well for you. They leave us with the interpretive obligation of trying to figure out what services are, as Justice Donoghue said to you, rather than what comps are. Do you agree with that or disagree with that?
I think the question was what the services, whether these are services or not whether they're comps. I don't think there was any disagreement among the parties that these were being comped, either free or discount.
I don't think so either. These are comps. There's no doubt about it. But that doesn't necessarily answer the statutory construction conundrum facing us, which is, are they services? You with me?
I'm with you, Your Honor.
Okay. If we construe, and I'm almost done, if we construe services as you like, doesn't the umbrella become unbelievably wide? Services is everything.
No, Your Honor, because again, I think you would follow the commonly understood meaning based on those 6 cases we've cited that all refer to admission tickets as services. That was all those cases, almost all of them, except for one, predate the enactment of the Gaming Act. If you look at the 1996 tax case we cited in our reply brief, Lebuti, that talked about admission tickets to concerts and shows and sporting events, again as services, and those all predate the Gaming Act. So I rely on that, and also some of the examples I gave, Your Honor, as the difference being between services involve human labor. If the casino wanted to start handing out stock certificates to Amazon or Apple, that would be personal property, as opposed to here, where it involves human labor. So I think that's the limiting principle. I think also my adversary's position is inconsistent, because if you look at page 45A of the reproduced record, Greenwood spent $8,000 on Jay-Z tickets, but they only sought a refund for $6,000 because 25% of those tickets was for food costs. So they recognize the principle that you have to look past the ticket to see what's being conveyed. And we didn't challenge that, of course, because, I'm sorry, a little mixed up there, but.
It's Justice Todd.
Go ahead, Justice.
It seems to me that your comparison to an Amazon gift card really.
I think I said gift certificate. I meant like a stock certificate, Your Honor, not a gift card. Gift card would be covered because it's a personal property.
Right. But
I meant
that
stock certificate
seems to me to be consistent with what Justice Weck was getting at a little bit ago, that if you give me as a comp a ticket to a Jay-Z concert, I have no interest in going, so I might sell it. So I don't see how that is distinguishable then from an Amazon gift card that would have value, because this piece of personal property, a ticket, if it's personal property, which I'm not interested in using. I can transfer, I can give it to someone else, or I can sell it to someone else for money.
I understand that, Your Honor. I think that might be true for other things that are excluded, like if the casino was to offer guided tickets to say, guided tour tickets to see Liberty Bell, or bus tickets from Philadelphia to the casino, certainly someone could transfer those, but they should still be excluded. I think it's, again, you have to look at the nature of what's being conveyed, and what's being conveyed is a service. I think that's the limiting principle, not whether people can do whatever they want with it.
Can I probe that? Can I probe that answer to Justice Todd? I go out and buy 100 Jay-Z tickets. Have I got personal property, or have I got services?
Well, I think, again, you have services because you have to look at what's being conveyed, and personal property. The difference between those two is human labor. So again, I think you have to look past it. Does it involve human labor, skill, advice, like a barber or a shoe shiner or a dry cleaner? And that's the difference.
Isn't that a counterintuitive?
Can I interrupt for 1 second? Justice White, can I interrupt for 1 second?
I'm done.
No,
I'm done.
Counsel, why don't you have both? A ticket is an intangible personal property. Put it on eBay and sell it. The service is the person that's going to sing, under your theory of the case.
I recognize, Your Honor, that there is an overlap. They both involve something that's intangible, and they both involve something that's representative. I mean, a stock certificate would be intangible, and it's representative of the value of a company. Ticket also involves in something that's intangible, and it's representative. However, the difference between those two, again, is human labor, skill, advice. I think that's the distinction. That's the dictionary definition, which supports our view. And I think if you make those two distinctions between stock certificates or insurance policies, which are intangible, compared to services, which involve human labor, that's the difference. And I think that's the principle.
And Justice White, I apologize. You want to follow up?
Well, I'll just briefly ask you, why isn't your more appropriate approach just to have the branch of government you represent communicate to the legislative branch, hey, folks, you've got entertainment in this other section. Why don't you put it in this section too? Or alternatively, apropos of what Justice Dougherty or somebody suggested, why don't you add in the word comps to the statute and define it? Why are you coming to us, though, to ask us to improve on the General Assembly's work here on the back of a taxpayer?
I understand the argument. I understand that position, Your Honor, and certainly it could be clearer. But I think it's clear enough here based on the cases we cited out of jurisdiction, based on the commonly understood meaning of services and some of the examples we provided. Now, if I could just transition, Your Honors, we think it's unambiguous, the term services, but I can recognize that there might be, if there was some ambiguity, I think the Commonwealth Court erred by first going to the rule of strict construction. This court has said at least 3 times since Greenwood Gaming was last year in 2014 that under Deckert, Snyder Brothers, and S&H Transport, that the rule of strict construction is a rule of last resort, and that you'll apply some of the factors of Section 1921 first. And we've focused on 2 of those here. One would be the consequences of a particular interpretation and deference. Our position on the consequences is that this would be, if a ticket is determinative, as the Commonwealth Court majority held, then there are going to be lots of ways for the casinos to avoid a tax. And I know I used some maybe more extreme examples, but the use of tickets is widespread. And again, I think their position is inconsistent, because you could take something that is excluded, like an airline ticket, or travel expenses are excluded, but under their interpretation, an airline ticket should get them the deduction because it involves a ticket or a bus ticket. Our position is that ours is the more reasonable interpretation. Otherwise, casinos could just avoid the. I think you're muted, Your Honor.
Thank you so much. Before you conclude, you said something earlier, and now you're coming back to it. if Parks Casino offers a tour or a ticket for a tour, and frankly, I don't see any relevance to or any importance to whether it's a ticket to something or doing the event itself. To tour to go see the Liberty Bell or Independence Hall, are those services?
Yeah, if it's a guided tour, yes, absolutely. Because you're receiving human labor of someone who has the skill, who can tell you the whole history of the Liberty Bell, and that's the difference.
And
the other
not a guided tour, if it's, I don't know if they charge it. I don't think they charge admission to Liberty Bell, but assuming for a second that some private company buys it and charges admission.
Right, I still think you're receiving a service. I think it's clear with the tour guide, but I still think you're being entertained to some degree. The one last thing I wanted to say, Your Honor, is I know we mentioned deference as another factor that weighs in our favor. And I know there's some disagreement among the court members maybe about how much deference should be given. I just wanted to point out that I think this is a bulletin, so there's might be a lower level of deference. But our position is that DOR's interpretation is a reasonable one. It doesn't clearly violate the legislature's intent. And again, I would not to keep making the same points, but again, we relied on those 6 cases that all refer to admission tickets. As,
okay, let me jump in on this. Then you're moving back to your other point. Before you jump off on this, before you conclude on deference, even were the court inclined to invoke deference, you have a non-legislative. There's no legislative rule here. There's a bulletin with no legal analysis whatsoever, simply an assertion. And it's not by the gaming board, which presumably has expertise here, but it's by the Department of Revenue. I mean, how is gaming in the Department of Revenue's wheelhouse such that we should simply defer to what somebody wrote a bulletin about it says?
Well, this particular provision involves taxing. I understand the Gaming Commission, if this had to do with the integrity of the game or licensing, then yes, I would absolutely agree with Your Honor that it would be entitled to no deference. But since we're dealing with the taxing part of the Gaming Act, that DOR has the expertise on that, and that it should be entitled to some deference. And I think, again, they're relying on the commonly understood meaning of services, the fact that these types of comps are very popular, things that casinos have been giving out for decades, and that's what the legislature would have had in mind. I have nothing further. I guess one other thing I wanted to mention, Your Honor, before I conclude is I know we haven't touched on it at all, but I think the Yoka dissent that the Commonwealth Court majority relied on was mistaken. That had nothing to do with taxing law. It had to do with the Pennsylvania Consumer Protection, and they relied on a case Klingner, which is a UCC Article 9 case, and under that Article 9, even real property interests are considered personal property, even a mortgage or a lease. So I think those 2 cases had no bearing on the question. I think the cases we cited are much more persuasive, and that Your Honors should rely on those. With that, if there's no more questions, I'll rest, Your Honors.
Thank you. Mr. Stewart?
Good morning, and may it please the court. Mark Stewart with Eckert Siemens for Greenwood Gaming and Entertainment. Your Honors, we submit that the Commonwealth's arguments are undermined in 3 key ways. First, by the language of the statute. As has been discussed, event tickets is not listed among the 5 enumerated exceptions in Section 1103, and it shouldn't be written in, and its absence shouldn't be ignored for the spirit. Section 1103 also broadly captures, quote unquote, any personal property. The exclusion applies to any personal property, which includes intangible rights to attend an event and occupy a specific seat. And a very significant portion of the cost of a ticket is tied to that intangible right. I've bought tickets in the nosebleed sections when I've gone to see a basketball game. The celebrities who sit courtside pay a very different price than I do for that seat. And that cost, that value, is directly tied to the personal property aspect of the ticket.
Mr. Stewart, it's
Yes.
Justice Todd. The celebrities are probably comped.
Yeah, excellent point, Your Honor. Additionally, in terms of the inconsistencies with the statute, Section 1103 specifically focuses on what the casino, quote unquote, distributes to the player. The casino, as has been discussed, does not perform any service here. We do not field a ground ball, play an instrument, throw a touchdown. We give tangible and intangible personal property to the player. And as was discussed in the questions, this scenario, that the player has the unfettered right to dispose of that ticket. He or she can sell it, they can gift it, they can just not show up. In that scenario, under the Commonwealth's view, because they never received the service, the casino apparently never distributed them anything. But that's clearly not the case. We distributed them tangible and intangible personal property, which they disposed of. The second thing that has undermined their position is this court's decision in what's been referred to as Greenwood 1 and the directive to strictly construe these definitions in the light most favorable to the taxpayer, excuse me. And it's important to note, as reference was made to the rule of last resort, we're not trying to apply the precept or the directive from Greenwood 1 to some other tax statute. Greenwood 1 interpreted the exact same clause that we are discussing here in this case. It's clause number 3 under section 1103(1). So we can't have a clause that is partially strictly construed in the taxpayer's favor, but partially not strictly construed in the taxpayer's favor. And finally, their position is undermined by the facts of record. As was referenced, they were stipulated, and the Commonwealth has agreed to all the facts required to establish that the tickets are both tangible and intangible personal property, and they've stipulated to the cost of the same. In terms of the argument about whether the Commonwealth Court's majority decision was unreasonable, I don't think that can be found here because of the express listing of exceptions in section 1103. And as was discussed, event tickets and entertainment are not included in that express listing.
Mr. Stewart,
Yes.
I think you've opened appropriately. Let me ask you, you mentioned that the legislature did not mention tickets specifically. But that to me is not persuasive because there's an infinite number of things that could be mentioned specifically or not specifically. So the legislature, as I discussed with your opposing counsel, could have said and the like. Here they did not. So I think the question comes down to is what's a service? Can you define a service for me and tell me what's inclusive in what is not permitted to be deducted and what is outside of it?
Yes, Mr. Chief Justice. Well, I think the definition of a service has been posited. It's human labor, it's effort, and the like. And Parks Casino did not perform any of those human labor or services in this instance. What it gave was a readily identifiable right and tangible property that was subject to ownership and that was transferable. And that makes it personal property.
I'm sorry, I apologize. You can finish your answer.
Okay. And while I understand Your Honor's view that it may not be dispositive that event tickets are not listed, it certainly should indicate that the position is not unreasonable. The decision of the Commonwealth Court is not unreasonable, and therefore, 2004. But in 2010, when they amended it to add the definition of gross table game revenue, which is also at issue here, they did, and we're certainly even more aware of the event ticket comps than they were in 2004. They again didn't add that into the statute, and they didn't add it again when they amended the law in 2017.
Yes, it's there again. You seem to place great importance, and I noted this in your briefs also, on the fact that there's a ticket. So assume that we have the King of Saudi Arabia at Parks, and he's got a line of credit for his gaming of $1 billion. And he loves Justin Timberlake. and the casino brings Justin Timberlake to his table, and Justice Timberlake sings him a song. Service or not a service?
Justin Timberlake provided a service to the King of Saudi Arabia, Mr. Chief Justice.
Okay. And Parks did not, but Parks facilitated him coming. I mean, it just seems to me you're cutting with a very sharp knife.
I would say that the money that Parks paid in that instance, you did not posit that Parks paid Justin Timberlake to sing to him. But
Bruce,
you can't separate
dollars. But the guy's going to lose $500 million in your casino, so it's a good deal.
It's good for the state too, since it gets 55% of that revenue.
It's Justice Bear. It's Justice Todd. I believe in all the many years that I've been sitting on this bench with you, I believe that's my favorite hypothetical you've ever posited.
Well, that is a great deal. Thank you.
Counsel, it's Justice Donahue. Let me see if I understand what you're saying. Services, as you see it, are services that are provided by employees of the casino?
Certainly, that would be correct, Your Honor. That would be included in the term services.
No, I'm not included. I'm saying, is that all that services are? It only includes services that are provided by employees of the casino.
The definition of
who works for the casino. You get a ticket to a free massage from a masseuse who is employed by the casino. Is that a service that is excluded from personal property?
That is a service if it's provided by the casino, absolutely. And the ticket would be a transparent pretext in that regard, and it also would not really afford the holder any intangible right. It would not have a separate and distinct use or cost.
Sure it would. You give somebody a ticket in their room. Take this to the salon, and this entitles you to a free massage.
That ticket has no cost to the casino. That ticket is the service is what's provided. As Your Honor noted in the definition of complementary services, the focus there is on that which is provided by the casino.
So, counsel, this is Justice Doherty. Am I understanding you as saying, based upon the hypo of the Chief Justice and what Justice Donahue just said, if the service is provided within the four walls of your casino, it's a service, even if a ticket is provided to obtain those services. However, if the ticket is for something outside the casino, aka a concert at the convention center or the football stadium, therefore it's personal property, or did you not just say that? I'm trying to discern.
Your Honor, the statute focuses on what the casino distributes. The casino, in these instances that you referenced, distributes a piece of personal property that is comprised of both tangible and intangible property. The service is performed by somebody else. If the casino actually performs services inside its casino, then obviously the casino is distributing the service in that instance. But there is an intangible, a player, which is the focus, what the casino gives to the player. When that player then transfers the ticket to somebody else, whether by selling it or giving it away, the service is ultimately performed by someone other than the casino, and it's received or experienced by somebody other than the player. It's a separate and distinct matter.
So it's Donahue again, and pardon me for maybe beating a dead horse, but I just don't find that helpful. Specifically excluded is food. Okay, so the casino gives a patron a ticket to go to Morton's in Philadelphia, which has no relationship to your casino. Is that excluded? It specifically excluded is food.
That would be excluded. It's food. Yes, Your Honor.
Yeah,
so the criteria. Even though it's food that's being served by Morton's in a city that's many, many miles away from the casino, it's still excluded?
Yes. There's no distinct, in that situation, that would be a clear pretext of what's going on. There's no independent value to that ticket. There's no separate discernible use.
I'm saying there's a ticket that doesn't say that it's not transferable. I'm saying it's a ticket for food at Morton's.
It seems to me that if Justice Donahue is a vegetarian and doesn't want to go to Morton's, she could give me that ticket and I could go eat a steak.
Correct.
Right. And
it's just not helpful. I mean, it just doesn't capture whatever it is the legislature was attempting to exclude from that which is deductible.
Well,
same thing with ticket. Your opposing counsel used the example. It excludes travel expenses. Let's say instead of reimbursing travel expenses, the casino sends a high roller an airline ticket to get them to the casino. The ticket is not marked, not transferable, can't be used by someone else. I mean, is that ticket, under your hypothesis, not problematic because it's a ticket? See,
an airline ticket is an actual travel expense, which is a listed exclusion. It's not, you're not trying to force the airline ticket into a service. It's one of the listed. Yes, Justice Wecht.
Yeah, because the point is, as my colleagues have elucidated, the issue isn't whether it's on the premises or off the premises, or whether there's a piece of paper that's a voucher or a ticket. It's what trumps there is that this legislature said travel expenses, food, refreshments, lodging, or services. So you don't maintain that you'd be able to deduct the cost of giving them a voucher for the Hilton down the street because the legislature said lodging. Your argument rather is about the meaning of the word services, and your argument is you win because it's ambiguous there. Isn't that the argument?
That is ultimately the argument, Your Honor, yes. At the end of the day, that is, we would submit that it's unambiguously not covered by services, but to the extent that obviously we're discussing it and debating it, and there's found to be some ambiguity, it has to be resolved in favor of the taxpayer, which is what this court held in Greenwood 1 in regard to the very same clause. And if I may want to say one more thing on the point of deference, I think it was discussed before, obviously the Harmon case and less deference to non-legislative rules. It's particularly important to note that the department's own regulations here at 61 PA Code Section 3.4 discusses and states that tax bulletins are, quote unquote, for informational purposes only, and, quote, should not be relied on or used in tax appeals, end quote. So if the taxpayer cannot rely on this tax bulletin or use it in tax appeals, the court should certainly not afford it any deference.
Mr. Stewart, before you finish, I just want to try to see if I'm not sure how my colleagues are doing, but if I can actually understand the hub, the principal criteria of your argument. So let me just start quickly with what you're not arguing. You're not arguing that it makes any difference whether the service, the entity is on-site or off-site. Is that correct?
If it's distributed by the casino on-site, we believe, or performed by the casino, I think it does make a difference. Yes, Your Honor. But if
all right, so let me try this. You would concede it doesn't make any difference because it would be pretextual if it's done directly by the casino, my hypo, that the boss comes and sings to the king, or that you provide a ticket. That doesn't matter.
I think providing the ticket to a Springsteen concert provides intangible personal property, and on the stipulated record, tangible personal property, because I would have that ticket framed on my wall if it was the boss. And frankly, there's a great market on Amazon for tickets like that too that you can sell. But
all right, then let me try it the opposite way. Last question, and then we quit. try, if you could, in just one sentence or two, to tell us exactly what a service is under the statute.
A service is a act of human effort, assistance, help, or advice provided and performed, distributed by the casino for the player. So a spa treatment, the valet parking, the poker massage that they provide to the poker player. Those are services that the casino distributes to the player.
Thank you very much. Any questions from anyone?
Just one follow-up. And performed by an employee of the casino. Is that part of your qualification? Gives you through and distributed by the casino, which doesn't quite narrow the context. Is it your position?
Yes, Your Honor.
Must be performed by the casino?
Yes.
Okay.
Mr. Schwartz, thank you very much. The court will stand in recess for 1 hour for a lunch break.
Thank you, Your Honors.
We'll start again at 1.